Okay, ladies and gentlemen, dear guests, dear colleagues, welcome to the academic forum which we are having today. We are very pleased always when we have a forum like this to present or to talk about some very interesting issues, especially like the EU law and things related to that. But we are even more happy when we have these academic forums and events like this, when some of our colleagues, of course, are presenting their research work on which they have been working on in the last couple of months, something like that. Our own Professor Aubel is a co-editor of this book which we are presenting today, and my role today would be more or less mainly in the moderating of this event. And in this regard, I would firstly like to present the guests which we are having today here with us. So, of course, as firstly already mentioned, with us is Professor Gareth Davis, who is the co-editor of the book which we are having today here with us. Then, of course, our own Professor Matej Aubel, who is also the co-editor of the book. And then we have a guest from Trieste, Professor Pietro Faraguna, which came in from Trieste, and of course our own also Professor Letnar Černić. So our idea more or less would be today to have the presentations of the book by the two co-editors firstly. So I will give the floor to them, then we'll have the interactions by the two panelists, and of course after that we will open the discussion, we will open the floor. And altogether we should be finished in something like an hour and a half or something like that. And without any further due delay, I would like to give the floor to our guest co-editor, Professor Davis. So please, the floor is yours.
Thank you very much. I feel very small. I notice my chair is lower than everybody else's. This is an old psychological trick to try and make people feel nervous. I'm not sure what game Matej is playing here. We'll see how that develops. But it's fine. I would like to start by saying, actually, I'm very grateful for this kind invitation by Matej and by the university to come to this beautiful town. I'd never been to Ljubljana before. People had told me that it was pretty, and it certainly is. I hope I'll have other excuses to visit in the future. Not only do they kindly invite me and put me up in a really nice hotel just around the corner, but they then put a plate of chocolate biscuits right in front of me, something which I really do appreciate. Okay, Matej asked me to just say a few things about the book and the idea behind it, and then maybe a few comments on my own interest or understanding of it. So I'll just do a little bit of background. I mean, this book arose, I was talking to an editor from Edward Elgar about something, I forget actually, and she said, we have this series of research handbooks and we'd really like to do one on legal pluralism and EU law. Who would be a good editor? Would you like to do it maybe? Are you interested? In my experience, publishers have very little idea of the content of academic disciplines, really. It's not their fault, I don't know anything about publishing. And I thought, how could anyone think that I'm a competent person to edit a book on legal pluralism? Because most of the things I've written about have been about free movement law, and I regard myself as a socio-economic lawyer. I have an interest in the Court of Justice, but that's in the adjudication of socio-economic issues, or discrimination law even, but a real constitutional pluralist. But at the same time, I found the idea kind of interesting, because pluralism is one of those ideas that, well, I find it attractive. It hangs, it's so you can use it in so many contexts. And so I was reluctant to say no, but at the same time I didn't feel qualified. So I said, there's no way I could do this on my own. I need a proper constitutional scholar to do it with me. We have to be co-editors. Fine, she said. And fortunately, Matej said yes, who I'd met at a big conference on pluralism that he organised in Oxford with Jan Komarek years before. And so I thought, okay, now we have a constitutional scholar who can police the content and make sure I'm not doing anything stupid, and together we can make this work. But in a way, why did I want to do it anyway? Well, the thing is, maybe it's simplistic, but I think I am quite simplistic in a way. But I mean, the pluralism, the underlying idea of pluralism, is this coping with difference, different opinions, in a way that is beyond simple resolution in terms of hierarchy. You know, there are so many contexts where you have conflicts of opinion or values, and one resolution, a typical lawyer's resolution, is to have a normative hierarchy, and then the question is simply, well, which one belongs above the other one? I mean, and in many situations that's entirely appropriate. We don't want a radically indeterminate. Well, I'm not sure if Mate maybe does want a radically indeterminate law. I'm not sure, actually. I think I have heard you arguing for that in the past. But in most contexts, one doesn't want that. But sometimes resolution, the clear placing of one court or norm or principle above another one, can lead to serious system-threatening conflicts. And so pluralism enters as a kind of almost an unfulfilled a promise that there's maybe another way of dealing with this, a sort of principle of tolerance which allows differences to coexist without either being subordinated. And precisely because it promises this without exactly making clear how it's going to be achieved, that's what makes it perhaps so seductive for the academic, because then you have to try and work out how this works, if it can. And as a socio-economic lawyer, my interest is in all the values that conflict within the free movement in Europe. That whether it's to do with people or goods or different economic models, there are many conflicts there, and how does one resolve them and how does one police them? And that question also comes up in an institutional sense. Which courts have the last word? Or can we avoid thinking in last words? Can we, if you like, avoid this conflict-based thinking and find another way of thinking about it? So that was my interest and why I wanted to approach the issue. But precisely because of this broader interest, I wanted to try and produce something a bit broader, because what I noticed had happened with the debate on constitutional pluralism is it began with, in a way, a bang. Some big articles by some of the giants of the field, Kuhn and Maduro, and I expect many of you have come across this. It was an idea that had a great impact, and quite deservedly, as a way of thinking about constitutional conflicts in Europe. As the debate developed, though, it became introspective, in my view. It became more and more about the details of the constitutional niceties. And I guess this is a normal academic dynamic, and in a way these details matter. So I don't entirely criticise that. But at the same time I felt then becomes a closed circle, a closed debate. It's not making the contribution that it could to thinking about Europe more broadly, because this pluralist idea is bigger than the constitutional theory concerning the Bundesverfassungsgericht and the Court of Justice. You know, there's more to pluralism than that. There's more to legal pluralism than that. And so I wanted to broaden it out. And that was always my if you like, my vision for the book. And in that sense, I'm fairly satisfied, because what we do have is we have a lot of solid constitutional theory, which is an important part of constitutional pluralism and of pluralism, and we have chapters that address exactly the things that you would expect. But we also have some more sideways chapters, quite an innovative one by Dmitry Kochinov on citizenship and pluralism, and the way pluralism has sort of developed almost out of anti-pluralism, out of a nationalist resistance to pluralism. I very much like the sociological and historical chapters by Paul Kier and Jiří Priban. I don't entirely understand Jiří Priban's chapter, but I'm sure it's great. It is actually interesting. But Paul Kier has a very interesting one, showing how pluralism has developed in Europe, tracing it back to using the ideas of the church and state. And it just gives you another way of looking at it. We have Foucauldian perspectives. Maria Cahill talks about subsidiarity and pluralism. And in a way, the point of all this, I thought, is I hoped that the chapters would be different, but also speak to each other, so that one would get an idea of the many ways in which pluralism is a relevant idea and might contribute to thinking, and that one could broaden it out and open things up, and it would be an integrated whole. In a book like this, a research handbook, you don't typically ask people to produce a major new theory as such. You ask people because of what they've already written, in a way. So you kind of know their perspective. So the added value is not necessarily that every chapter comes with a great new idea. Some actually do, but it's putting them together. Hopefully they speak to each other and one gets a broader idea of what pluralism and constitutional pluralism might mean. And in a way, I always thought, what am I going to do with this book? What's the point of this book? Academics have time to ask questions like that. And my vision was actually, in a way, the PhD student. Because it's not a textbook. But at the same time, it's not a book that says, we come with a new theory, not like a monograph that says, I've got a whole new idea. And I thought, pluralism and constitutional pluralism have now entered the canon. There are many, many PhD researchers in all kinds of fields, from the national, the constitutional, the European, who will come up with this idea and at some point think, I need to understand pluralism. In a way, I thought, my vision is that the supervisor of the PhD student, when the PhD student says, pluralism, what should I do? Can take this book down and give it to them and say, read that. It might not be everything you need, but it will take you everywhere you need to go. Some of the chapters will open up other doors via their footnotes. This will, and if you follow those leads, then you'll know what you need to, you'll know what people are thinking about pluralism, and you'll be ready. I don't know, I mean, I feel fairly satisfied with the results, not really for me to judge whether it's succeeded, others will comment on that, but that was in a way what I wanted to achieve, that it would open all the doors. It wouldn't end debate, but it would take people into it in a good way. And I think what was important to that was having a mix of scholars, and we have some of the big names, the grand old men of constitutional European law, Tuori and Walker and Dan Kellerman, so on, Peter Lindsay, I like his work a lot, and Pavlos Eleftheriadis for his unique perspective on monism and pluralism from Oxford. But I didn't want to fill the book with them, partly because I think, at least in my faculty, you're not allowed to have books consisting entirely of middle-aged men anymore. So we kind of, we broadened it out, and we have a nice perspective, a fairly novel and interesting other younger perspective. The ideas that will probably be bigger in the future. The up-and-coming stars. And I feel it has been it's worked out quite nicely. It's quite original. For me, though, the motivation was this question, a way of unresolved power and how to live with it. And it seems to me it's one of the core questions of Europe, perhaps of constitutional theory. I'm more of a student of Europe than of constitutions, but the two, of course, speak to each other. One of the ideas that attracts me, which has come up in European debate again and again over the years, is this idea that if you have resolved power, where all the lines of hierarchy are clear, you create tyranny. And I think that's true in a national context as well. If the Supreme Court has the last word over constitutionality and no one can contradict it, you create a court that's above the law. And I know that constitutional textbooks don't always say this, but it's a problem. You create, in a way, potential tyranny. And so you need gaps, you need holes, you need areas that are out of the reach of the courts, or gaps in jurisdiction. You need, in a way, structured imperfection. Power is problematic, and if you have perfect power, you create tyranny, would be my argument. At the same time, of course, it's a sort of faculty argument. It's the kind of argument you have the luxury of making when it's not real. But unresolved power can create great uncertainty and confusion, and I think distress amongst those who are subject to it, who want order and want to know how things work. My own chapter and my own thinking is primarily about courts and the Court of Justice and Supreme Courts, quite traditional questions. And again, this question of who gets the last word on issues of value conflict or constitutional interpretation. And my thinking in the chapter here was maybe one has to live with interpretative differences, accept that courts may fundamentally disagree about what a text means, what I call interpretative pluralism, and live with that. Not try and end that, but just treat that as part of the system, which we do have in most systems. Actually, that is the status quo. The myth is of a pyramid and a uniform interpretation trickling down. But in most countries, Supreme Courts accept that appeal courts and lower courts manage to escape their interpretations and undermine them to some extent. It's a constant churn of power in which nobody fully manages to subordinate anyone. I find this very attractive. I put it forward as an interpretation which can deal with the irresolvable tensions and conflicts within the EU. At the same time, I feel uncomfortable about my own conclusions, more uncomfortable than I admit to in the chapter, actually, in the sense that maybe I'm too much the lawyer. Maybe I was trained too much the lawyer. I still feel uncomfortable with the idea that the answer is you don't entirely know what the last word is going to be. You don't entirely know which court is going to have the last word. There is a degree of ultimate uncertainty. I suppose that's realistic, but I can understand how that itself can create angst, can create anti-European feeling, can create a sense of dissatisfaction with the law. And so I have the feeling that, although I put this idea forward, it's also not the last word on the matter. I suppose I struggle with a form of internal pluralism, and that just shows in a way how ubiquitous the idea is and how you can apply the label to almost any context. So I'll leave it at that for the moment, but perhaps in the discussion we'll speak more.
Okay, thank you very much, Professor Davis. Thank you for the information and the background information behind the book, and some very interesting lineouts which can be definitely discussed later on in the debate. But please, our colleague, Professor Aubel, who co-edited the book, please maybe your views and some initial ideas on the book.
Thank you, Gorazd. Thank you very much to all of you for coming. It's a very dreary night outside, so it's great to have you here. Thank you very much for taking time, and especially grateful to Gerrit and to Pietro to have made the efforts and to spend this evening with us. I will follow up where Gerrit has basically stopped, and I will also bring back to mind the memories when I received his email. It must have been somewhere around 2015, asking me if I want to take part in this project of an edited volume on legal pluralism. And I have to say that this email faced me with a couple of concerns. First of all, being an editor of a book with many, not just middle-aged men, but these grand academic personas, can be a great pain and suffering, because all these people promise that they will deliver because they want to be nice, but they tend to be much less nicer when they're missing all the deadlines. And in that sense, Gerrit sort of comforted me, by saying, well, we'll be two of us, so we'll be doing it together, we'll be chasing them together. And it's always more comfortable if there are two of those who are suffering with the same problem. Another reason that sort of bred some skepsis in my mind was that I sort of suffer from a hangover caused by legal pluralism. I spent most of my research since my studies at NYU engaging with the idea of legal pluralism, constitutional pluralism, with the idea of difference and importance of difference in EU law and how to deal with it, as Gerrit has mentioned it. However, those times from 2003 to 2009, where I was really just intellectually engaging with this idea, at those times the European Union was completely different in comparison to the European Union in 2015 when I got this invitation. In 2003, there was a great euphoria, literally not just euphoria, but euphoria, because of the enlargement, the success of the enlargement, the Big Bang and the coming back to Europe, the return to Europe, all this great narrative, the narrative of success and great optimism. And even more so in the years 2003, 2004, we were all looking forward to the adoption of the proper constitution for Europe. And in comparison to that, in 2015, we are thinking of the European Union, which was on the brink of a collapse. There were words about the center and the periphery. Harsh words have been exchanged between the center and the periphery. And on the top of it, not just these internal challenges were vibrant, there was also an external challenge of migration that sort of created an impression that the European Union will simply topple. So, and at that particular moment, it also seemed to me that the debate on constitutional pluralism and legal pluralism has been to a certain extent already exhausted. And I was skeptical if we still have something to say about it. And Gerrit is right that by the time the idea of legal constitutional pluralism in the European Union has become a canon, or rather the canon. To a certain extent, it's become the ideology of EU law, because all of a sudden everyone was pluralist. In 2003, it was still the idea of uniformity, the idea of une certaine idée d'Europe. We are all going towards uniformity. We must finish up this European construction. With the weakening of this, with this glue, everyone was pluralist. So my skepticism was: hasn't the debate been exhausted? Do we still have something to say about it? And I have to admit that I was sort of concerned that when we'll be approaching these authors, that they will just say, well, we've said everything that we have to say about this topic. However, to my great surprise, and also I guess Gerrit's surprise, was that that the reaction, that the response was enthusiastic. It really was enthusiastic. And also when we received the actual pieces, with a little bit of a delay, admittedly, we were also quite enthusiastic about the contents of what people have actually produced. And we realized that by far the idea, the theory of European constitutional pluralism hasn't died out. And this our impression was even reconfirmed during the conference last year when we held, that was held in Amsterdam, and where we invited these people to have their say on their chapters. And there it was clear, not just because of the authors who were there presenting their pieces, but because of the great audience that we assembled. We saw that really this idea, this theory is still alive and kicking. That it is still, it is an intellectually engaging idea. So be it. I mean, this can be also be, this can come across as in a very self-celebratory manner, which is not my purpose here. And since this is not my purpose, I'd like to, in these few minutes I still have left, raise one particular issue, which I think, or take on legal pluralism, which is also represented in this book, and I think it's becoming also increasingly prominent in the heads of those, or in the approaches of those who are critical towards legal pluralism. The chapter by Kellerman argues that legal or constitutional pluralism, no matter how innovative an idea or theory, it can be blamed for what is going on now in Central and Eastern Europe. If not blamed directly, it has at least provided the instruments. It has provided the language of justification for these rogue backsliding regimes. And he's saying if those constitutional pluralists, those legal pluralists who continue to cherish the European integration, they should get away, they should get rid of this theory, because it's increasingly harmful in practice. It is giving the resources, it's offering the resources to Orban and the like in justifying their claims towards their identity, to their difference, in order to justify the particular shapes of their regimes that are increasingly incompatible with the shared values of the European Union. I disagree with that approach. I argue that legal or constitutional pluralism, properly understood, is in fact a theory that filters out this kind of hostile attempts of hijacking their own politics by these politicians, as well as taking away from the fundamental values of the European Union. And to illustrate it with a small, tiny example why I believe that, I think we could rely on the recent deviation by the Slovenian Supreme Court from the European Court of Human Rights. If you remember, the Slovenian Supreme Court said, it publicly announced on its website, that it rejects the decision of the European Court of Human Rights in a particular petty matter because it disagrees with the content of this decision. And from the legal pluralist perspective, this is something the courts, especially the Supreme Courts, the highest courts of the member states, including of the Council of Europe, they have the right to do. Garrett would call this is an interpretative disagreement. So of course they have the right to do it, but this doesn't stop here, because legal pluralism requires much more. Legal pluralism is not just about plurality, that you state your differences, but you have to engage with the other, with the one that you disagree. So you have to state your reasons, you have to justify why your authority is more persuasive in this particular matter, in this particular interpretation. And once you have subjected the decision or the announcement of the Slovenian Supreme Court to this test of legal pluralism, it was clear that it wasn't about legal pluralism, but it was a sheer deed of ignorance. Because what the Supreme Court actually said is that the European Court of Human Rights wrongly interpreted national legislation, which is, we all know, something that the European Court of Human Rights doesn't even do. The European Court of Human Rights interprets the European Convention of Human Rights. So, the gist of this matter is that once you, as from the legal pluralist perspective, once you require the courts to engage in this dialogue, to state the reasons for defending their authority, to state the reasons for defending their particular bits and pieces of constitutional identity, they have to come up with persuasive justifications. And in this particular case, there was no such thing as a persuasive justification, and even less has the Slovenian Supreme Court tried to evoke any irreducible core of the Slovenian constitution that would need to be defended against the European Court of Human Rights. So my argument is that Kellerman and the likes, I think they appropriate too negative a construction on legal pluralism. On my reading, legal pluralism is not an instrument that facilitates authoritarian drifts away from the common values. But it's indeed, if taken seriously, a shield against those authoritarian attempts. Thank you.
Thank you very much, Matej, for bringing also the Slovenian issues into the debate and for, of course, explaining the background also from your side. And as mentioned before, we also have our guest from Italy with us, Professor Faraguna. So please, the floor is yours, the next one to comment.
Poštovani kolegi in kolegice, kljub temu, da sem iz Trsta, žal ne obvladam slovenščine, opravičujem se vam, ker bom nadaljeval v angliščini. So, many thanks for our wonderful host for inviting me in Ljubljana again. It is very nice for me to come to Ljubljana because, first of all, it is the closest university we have from Trieste, but nonetheless, I mean, the academic relationship between this academic institution were not always so very extensively developed, and I think this has a lot to do also with academic pluralism, let's say, and so I hold this connection that we have very important. And although I'm originally also from Trieste, I just started a new academic position there in a few months, and so I very much hope that we will find a way to deepen our academic relationship, even though every time I come to Ljubljana I see so many news, and the last time is that I see a new university, a new seats, and compared like with our way of changing things in the university, this is really striking from my perspective. But so really I hope that the next chapter of our discussion will be held on the other side of the former border, let's say. So and moreover, thank you very much for inviting me to comment on this edited volume, and it is a great edited volume, and edited volumes are not always great. I would even say that usually edited volumes are far from great, and it is a much harder challenge to write a successful edited volume, because as we know, as potential authors of edited volumes, even though editors are called to so persuade authors to deliver something that is homogeneous. So we know as potential authors that we try just to deliver what we have, and I think that you managed to do your work as editors in a really great way on a very challenging topic, and I think also with a very challenging methodology. First of all, because research handbooks are somehow based on an oxymoron. So somehow, if we think at a handbook, it has descriptive purposes, and so even like it is a teaching instrument, a handbook usually speaking. But then a research handbook is something that has to do with speculation, with research, new ideas, and I think that like writing a research handbook on constitutional pluralism should somehow merge two oxymorons, because also constitutional pluralism is, of course, an oxymoron, and you did a great job in facing this double oxymoron. And you did it in a very pluralist way. First of all, because authors are selected with a pluralist methodology, as Gareth already emphasized. So you had contributions for, let's say, established, because old is not nice, but like established scholars, and at the same time you had contribution from emerging and young scholars. Here I can say that they are really young, and you had contributions from, let's say, Northern Europe, Southern Europe, Eastern Europe, Western Europe, Central Europe, which is a concept that is much more important for us, and it is often just overlooked, the existence of such a concept of Central Europe. And I think that also from a methodological point of view, it was great having these contributions from historians, also like an historical and a sociological perspective, and you already emphasized it. And I think that this was something that was really missing in the constitutional pluralist literature. And moreover, I think it was a great idea to move beyond the constitutional language, also because the constitutional language is making constitutional pluralism unfamiliar with some scholars, just because of, I think, this oxymoron. And I think that facing this topic through the language of legal pluralism is a very nice strategic move, let's say. And this also, I think, made it possible. And this is another very so truly pluralist approach. You had also contributions from authors who are clearly skeptical and critical towards constitutional pluralism. And I think this is also an added value of the research handbook. And then, I mean, our research handbook has two purposes, I think. One is mapping the debate, and you did it in a great way, also because probably, I mean, because of your established scholarly contribution to the field. I mean, you had the possibility to collect the authors who are really the authors who like developed this new but still mainstream idea, and we'll get back to this transformation. And moreover, a research handbook has the purpose of like moving things a little bit further. And I think that in this book we don't have only just a conceptual map of the challenges of constitutional pluralism, but we have many new ideas. And I think that this is also partly connected with the fact that applying the, let's say, old scholarship of constitutional pluralism to this new world, it is something that raises new ideas, because as Mattei said, even though, I mean, the constitutional pluralism is in itself a new idea, it was developed on a state of affairs that is completely belonging to a different age. And so this is a great added value. I will get to 3-4 points, and the first point is that, and I think it's emerging from this edited volume, and it could be an interesting point to discuss here together, is the fact that constitutional pluralism was born as an alternative approach, and it was born like more or less, probably, I mean, the origin of constitutional pluralism is the discussion of the Maastricht-Urteil by the Bundesverfassungsgericht, and the idea that the Maastricht-Urteil in the mainstream European literature was something bad, of the dog that barks once again, the German dog, and so that claims sovereignty. And one alternative reading of this historical and judicial event was the one from McCormick, who somehow, in a very alternative way, gave a reading of this judgment in positive terms, let's say. Nowadays, constitutional pluralism is, and Mattei already emphasized it, it is far from an alternative theory. Everybody in the European constitutional scholarship, let's say, is a constitutional pluralist nowadays. I think we are not allowed to be non-constitutional pluralist. And I don't know if this is somehow connected just to some, let's say, I don't want to be in a bad academic condition of what I'm saying now, but it is connected with the success of some constitutional pluralist author and the academic success, and this somehow triggered the movement of many authors in the field of constitutional pluralism, because otherwise you could not get a job in Europe without belonging to this winning scholarly group. Or maybe it is connected with the success of the methodology and of the idea of constitutional pluralism. Or moreover, additionally, an additional justification could be connected with the fact that constitutional pluralism started to be developed through so many substreams that, of course, everybody is a constitutional pluralist, but there is no more one thing as a constitutional pluralism. And here, the scholarship of Mattei, I think, is not only in this edited volume, but I'm referring to your article in the German Law Journal, for example. So the mapping of the different substreams of constitutional pluralism are. It is very important to understand if we still have something that is constitutional pluralism. And if we do not have something that is not constitutional pluralism, of course, if we don't have the negative side, maybe we could end up to think that constitutional pluralism is completely useless, because I mean it is just setting the field of like the scholarly debate, and so there is no added value in identifying something as constitutional pluralism. But I think that the challenges that are emerging from the legal problems that the European Union is facing nowadays. So the challenges are pointing in a completely different direction. So constitutional pluralism seems to be much more important today than it was yesterday. So first of all, because we had, I think that constitutional pluralism also had the purpose of somehow reconciling the centripetal forces of unity in the European Union with centrifugal claims to difference. And nowadays I think that the claims to differentiation and also to judicial resistance to the supremacy of the European Union are much more stronger than yesterday. Probably if we think at any kind of judicial epiphany of proper resistance to the principle of primacy of EU law before 2009, it is very hard to imagine any single case that is not connected with the German Bundesverfassungsgericht jurisprudence. And the German Bundesverfassungsgericht jurisprudence is mainly more a piece of scholarship than a piece of judicial resistance. Then, if we start from the Slovak pension case in 2009 of the Czech court, then we have an impressive number of judgments that are resisting the principle of primacy of EU law. And this is stemming somehow from concrete problems, and probably it is just connected with the fact that the European Union law, that EU law has much more impact on ordinary life, and therefore we have many more occasions for conflicts. And if we have occasions for conflicts, then we can have also occasions from pathological conflicts. And here I very much agree with the approach of Gareth. I mean, I think that we should not account this as a negative development, and on the contrary, I think that interpretative pluralism is somehow adding richness to the debate. And of course, I mean, law is developed through like an interpretative trial and error process, and so I mean we should not be scared about it. As lawyers, we should be enthusiastic about it. And one of the last cases we had so at one point it seemed that constitutional pluralism was completely useless, and then or on the verge of collapsing, and then if we see concrete cases of conflicts, and here maybe as I'm coming from the Italian jurisdiction, one of the last cases of this kind of resistance was this Tarico case that somehow involved the Italian Constitutional Court and the European Court of Justice. And in that case, for the first time, I will not go into detail, but for the first time, a Constitutional Court of the European Union submitted a reference for preliminary ruling to the European Court of Justice, explicitly affirming that the violation of constitutional identity of a member state was at stake. And so it seems to be the concrete application of the German Bundesverfassungsgericht theories in practice, and it seemed to be an, let's say, atomic problem, like the use of the atomic weapon. And at the end, what happened? It happened that by means of interpretation, this atomic weapon revealed to be just a tool for judicial fine-tuning of interpretation, and so somehow it's confirmed the fact that the theories of constitutional pluralism are working even in practice and not only in academic circles. But on the other hand, I think that constitutional pluralism was developed with the purpose and the idea of emphasizing the term of differentiation in the attempt of reconciliation of unity and fragmentation, let's say. And probably nowadays the historical developments are pushing us to emphasize again that this reconciliation is not just the overcoming of unity, and on the contrary, I mean, the protection of differentiation is not a protection at any cost. And I think when you referred to Kelemen chapter and his critics, I stand a little bit more on the side of Kelemen, because somehow I think that the theoretical tools used by constitutional pluralism have been applied by not so much political actors, but much more by judicial actors in the cases of the Polish and Hungarian crisis. And in particular, I'm referring to the Hungarian crisis and the Hungarian case. I mean, one of the cases, and Matej is also approaching this case in his chapter in the book. So one of these cases had to do with a sort of Hungarian application of German theories of constitutional identity, and of course it was very clear for any commentator what was the purpose of the Hungarian Constitutional Court. So the Hungarian Constitutional Court used the German concept just to say, okay, we don't want to be subject to the compulsory distribution of quotas of migrants in Europe. And when I first heard about this new judgment, more or less 1 year ago, I don't remember exactly when it was issued, I'm not that good in Hungarian, maybe many of you aren't, and so I just read some comments of, let's say, liberal authors commenting this case in English, and the idea I had was that so the Hungarian court was completely like out of any possible conceivable field of constitutional democracy in the Western world. And then many months later, I had the occasion to read the motivation of the judgment in English, and I was very much surprised because, legally speaking, this judgment was amazingly sound, and somehow, I mean, the preciseness of the implementation of German theories that are developed with one purpose, and their application with the idea of reaching another purpose was amazingly precise. So what I think that we have to emphasize and stress now is that the instruments of constitutional identity, for example, and I think that so a large part of the debate is somehow connected with the protection of national constitutional identities, that should somehow not be left to the use of any actors without any limits. So, in short, constitutional identity is a relevant element of protection of diversity as long as constitutional identity is constitutional. So it is compatible with the fundamental principles of constitutionalism. And these fundamental principles of constitutionalism are expressed in the treaties and not just in our minds. So the fundamental pillars of Article 2 of the Treaty on the European Union are part of the same tension between a centripetal force and a centrifugal force. An additional point, and then I will leave the floor to Jernej. I'm not fully sure that constitutional pluralism is something that only belongs to the European constitutional debate. I think that exactly the same problems are problems that are faced also by domestic jurisdictions. When we say that no single authority has the last word in deciding constitutional issues, this is something we are familiar with in any domestic constitutional jurisdiction. And even where maybe the president, the political actors, they have more power, and in other places, constitutional courts, they have more power. But then we know that if we have atomic conflicts, there is nobody who is in the position of solving the conflicts with our ultimate power. And this is the quintessence of a pluralistic constitutional state. And so I don't think we have to keep constitutional pluralism just to the uniqueness of the European legal space. And maybe, and here I close, the national debate on problems that are connected with constitutional pluralism can teach us that maybe just like the questions about the ultimate authority, this is a question without answer, and maybe we should start to think more at other questions with more likelihood of getting a good answer. And we should maybe start to concentrate more on the importance of having the right to the first word, and not with the right of having the last word on constitutional conflicts. And I think that, for example, the availability of many more constitutional courts than in the past to submit a reference for preliminary ruling directly to the European Court of Justice, this is part of this unconscious new consciousness of being entangled on a system where nobody has the ultimate authority, but sometimes it is even more important to have the right to the first word to shape the constitutional tone of the conflict. Thank you very much.
Thank you very much, Professor, for this in-depth comment, and also for some very interesting ideas which you brought into the debate. We'll definitely get back to those. So the next commentator would be our Jernej. So please, the floor is yours, Jernej.
Thank you very much. Good evening. It's a pleasure to be on this panel. First, of course, congratulations to both editors, Matej and Garrett, for this book, which surely contributes to the debate on the legal pluralism. And of course, I know myself that it's very difficult always to edit a volume. You know, it's a lot of hard work, not so much in writing and editing, but getting, as you said, Matej, authors together and getting to keep the deadlines. No? And I remember when my friend Tara Van Gogh edited a book 3-4 years ago. There were like a lot of authors, I think like 22 authors. And most of them, they delivered on time, but there was one person who, even after we sent several reminders, did not send an email. But he then, well...
This was Matej.
No, it wasn't Matej. It wasn't Matej. Then he finally replied a year after the book was already published, saying whether he has time to deliver a chapter. So it's a hard work. But then, of course, I mean, for those of you who are not legal scholars, I mean, edited books are kind of like peculiarity in our legal academia, you know. Whereas, for example, in natural sciences, when you read some of the articles, there are like 15 authors, you know, being co-authors of an article which has like 5 pages, you know. But in legal science, this is the way we do our work. Of course, there is a disadvantage comparing to the natural science that, of course, I hope your book will be, you know, exemption to that. Edited volumes are not so much cited than articles in natural sciences, unfortunately. But of course, I mean, going to the point of legal pluralism, I will address and refer to these issues from my point of view, which is human rights law, you know. And I was a bit disappointed not to see a chapter on legal pluralism in EU from the human rights perspective, even though there are some chapters which refer to human rights, as Francois Milland's chapter. And of course, since a long time, I a bit struggled how to define, you know, legal pluralism and constitutional pluralism. Also, for you in the audience, probably it's a bit difficult to understand what constitutional pluralism is, what legal pluralism is, how to define it. And I'll try to just to start my delivery. I'll talk about 3 judgments, recent judgment by the European Court of Human Rights, where the court basically found violations of a couple of rights concerning Slovenia and Spain. And Matej already mentioned one judgment in the matter of Pro Plus versus Slovenia, which was a judgment where the court said that Slovenia violated the right of fair trial because the Supreme Court did not allow for a public hearing in one competition law matter. And I remember that we exchanged some emails with Matej in this regard, whether one could describe, you know, this public statement by the Supreme Court, which followed. They are bound by the judgment of the European Court of Human Rights. Can we describe this really as a constitutional pluralism or a legal pluralism? You know, Supreme Court trying to engage with the European Court of Human Rights, or is this only a mere abuse, a pure abuse of the rule of law? You know, right to fair hearing. Is a right to fair hearing an issue where one could have a different approach, you know, within the European Union, member states of the Council or, of Europe, or is this a uniformity, you know, where there is no exceptions to the rule, where there is no, should be no disagreement, consensus. No? And then the second judgment is it's a judgment from August of this year against Slovenia. It's called Koprivnikar versus Slovenia. It's a judgment concerning a violation of principle of legality. The students of law, you know that principle of legality is the pillar of every free democratic states. Basically, it's the pillar of the rule of law. Without the legality, there is no rule of law. And in a decision by the Supreme Court of Slovenia, which tried to execute this judgment, Koprivnikar versus Slovenia, because Mr. Koprivnikar then filed a request for a rehearing of the procedure. The court engages, as you said earlier, Matej, the court engages with a judgment by the European Court of Human Rights, but then it disregards it and says that we will not follow Koprivnikar versus Slovenia because our approach to the cumulation of sentences is different than the European Court of Human Rights. And again, I don't have an answer to that. Is this legal pluralism, or is this allowed constitutional pluralism, or is it just mere abuse of law? If the European Court of Human Rights says that principle of legality was violated, is there any room for discussion left? Or there is, as the Supreme Court seems to say. And then the third matter is a judgment also from a couple of weeks ago called Otegi Mondragon versus Spain. It's a case concerning a Basque opposition leader. He was arguing before the European Court of Human Rights that Spain violated the right to impartial and independent proceedings because one of the judges which sat on the case, she publicly criticized Mr. Otegi Mondragon, and she also was a judge in one other case against Mr. Otegi Mondragon. And the European Court of Human Rights said, well, it's quite clear, our case is quite clear. This judge who publicly criticized Mr. Otegi and even sentenced him before, violated the right to impartial, independent tribunal. So there's a violation of right to fair trial. And after this judgment, of course, there were a lot of criticisms published in Spanish media, kind of similar to what we experience here in Slovenia. Sometimes kind of similar to what some of the judges of the Supreme Court often say. They said, most of the commentators in Spain said, well, this is only one judgment. We should not, enlarge the judgment to other cases. It's not a systematic and general condemnation of Spain, and so on. Kind of similar dialogue and response what we see often here in Slovenia. So again, the question is this, constitutional pluralism? Is there any room for discussion left when the European Court of Human Rights says that a country has violated the right to independent and impartial tribunal? Or there is, maybe. Or there is a space. So then the question, my understanding of legal pluralism is this, that it is basically trying to explain different competing claims to legal authority. So basically it means that there are two or more normative systems which basically try to regulate the same situation. No? And of course, as a human rights professor, my question first is, of course, how desirable is legal pluralism for human rights protection? No? Is it really desirable, or it leads to incoherent protection of human rights, or it leads to different standards, or it leads to these objections of constitutional identity, saying that we are different, so we can interpret right to fair trial differently than the European Court of Human Rights. And I'll try to answer this. I don't have an answer to this question, but I'll try to explain this by discussing three subfields of human rights, which I have been working on in the past years, and try to see whether legal pluralism can provide an answer to human rights, whether human rights can use legal pluralism in a certain way. And the first subcategory of human rights which I'll address is our proceedings before the court arbitration for sports. Court arbitration for sports is the main body which resolves sports disputes in an international arena. Basically, all athletes which want to compete at international competitions and Olympic Games, they have to sign this obligatory compulsory arbitration clause, saying that if a dispute arises, the court arbitration for sports will resolve their dispute. And the proceedings before the court arbitration for sports are quite peculiar. They more resemble arbitration proceedings than judicial proceedings. So there are, in most cases, there are three arbitrators. They are nominated by the Olympic Committee, and proceedings, they at least raise some doubt as to the fair hearing, because they're not public. Those arbitrators are nominated by the national federations, so it's not anybody can become a judge, arbitrator, and so on. And just recently, this summer, a couple of months ago, European Court of Human Rights again delivered a decision as to the legality and compliance of those hearings before the Court of Arbitration for Sports with the European Convention on Human Rights. There were two cases concerning one former Romanian football player, Mutu, who was found for doping violations while playing for Chelsea. And the second one was Claudia Pechstein, several-time Olympic champion. She was also found, and there was some discrepancy in her blood picture. No? And they were both excluded from the international competitions, and they applied to the Court of Arbitration for Sports, which confirmed the sentencings by international federations. And they were all the time claiming that the proceedings before the Court of Arbitration for Sports are not fair. They're not independent and they're not partial. Not impartial. And then thereafter they complained to the Swiss Federal Tribunal, which is an appeals body against CAS decisions, but the Swiss court said that everything is okay with the CAS decision. And the European Court of Human Rights just recently said, well, most of things are okay with the proceedings before CAS, only there is a violation of right to fair hearing because the proceedings are not public. No? The CAS should reform the proceedings in order to make them public. And here, again, there are two competing claims to the authority. You know, CAS and European Court of Human Rights. And the question again is, I mean, how desirable is legal pluralism in this respect as to protect human rights of those athletes which resort to the Court of Arbitration for Sports? I don't have an answer, but just I'm highlighting the problems which Garrett and Matej outlined in the book. And the second example is the sub-area of human rights which is called business and human rights. Business and human rights is an area which basically tries to argue that also non-state actors, companies have human rights obligations. And in this area, there's a huge deficit with access to justice for victims. Now, victims do not have a proper access to justice. For example, if a Slovenian company is complicit in violating human rights, for example, in Belarus when they are building a new hotel, or Slovenian company is allegedly violating their right to life or prohibition for torture when they're selling their medicines in Russia and so on. So there's not a lot of ways where victims can go to seek justice. There is no international mechanism. There are very few domestic systems which would allow for extraterritorial applications of human rights. And thirdly, there is also no regional mechanism where victims could go. And of course, given this lack of supervisory mechanism, we have seen that in the past decades a rise of private regulations. So different industrial sectors, such as diamond industry or mining industry, they develop their own codes of conduct, and they develop their own internal supervising mechanisms where victims can refer to when violations occur. But those mechanisms, in a way, do not provide for these basic rights of fair trial, impartiality of tribunal and forum, and independent tribunal. So again, we have these different competing authorities, and again, the question is whether, what value does legal pluralism brings to human rights protection. And then, of course, last but not least, the last is the relationship between the different normative orders in the European system of human rights protection. Here I'm referring to this normative legal pluralism, existence of different legal orders for protection of human rights in Europe. There are at least 5 different systems from Council of Europe to European Union. And again, the question is, for example, if a Court of Justice interprets right to family life as including only this nuclear family, parents and children, and then in the same case, European Court of Human Rights expands this family definition to include also cousins and grandchildren and so on. And then again we have 2 different competing claims to authorities. European Court of Human Rights and European Court of Justice, they try to claim what is best protection of human rights. And then again, the question is, I mean, how desirable is this legal pluralism for human rights protection? Because from human rights perspective, legal pluralism it's quite controversial. There are some authors which claim that, for example, European Court of Human Rights does not allow for legal pluralism. It's very uniform, no, because it tries to spread uniform standards across the European continent. I wouldn't agree with that because there is as some of you know, there is a concept of marginal appreciation, which allows for countries to include their legal traditions, customs into the protection of human rights. So those are basically 3 challenges I want to put out to the panelists and to the audience. Maybe we can address them in the further debate.
Thank you very much, Jerne, for bringing the human rights perspective into the debate. And of course, now we have heard the 2 commentators, and before we give the floor to the audience, of course, the editors can now respond maybe to some of the ideas that were brought up by the 2 commentators I mentioned before. So please, the floor is yours. And as for the audience, after the comments will be made by our co-editors, please, the floor will be given to you so you can maybe prepare your comments, questions, and so on. But please, first.
Okay, I mean, we'll be brief because I'd be very interested to hear comments from the audience. So I'll just be a little bit selective in a way. I mean, I think your point about there's no chapter on pluralism and human rights is quite a good point, actually, which we could argue our way out of by saying, yeah, that's ECHR law, but nevertheless, I think it's a fair point. And human rights protection is one of those issues where you could say, well, you know, what are the values of certainty and the values of pluralism? But, you know, I would respond by saying, personally, I regard pluralism as a frame rather than a solution, and as a fact rather than a proposal. So, in that sense, when we are saying this Slovenian dispute, which Mate has explained to me a little bit, I'm not familiar with the details. I mean, is this really pluralism or is it just a stupid judgment? It can be both. You know, I mean, pluralism isn't an answer. It's like, well, if you're pluralist, then you have a way of dealing with the world. It's a frame. It's like equality in that sense. It doesn't tell you what to do in any given dispute, but it provides a common language for people who disagree, and that can be constructive. You know, a common frame. And in that sense, I'd say it's just a fact. If you believe the criteria for thinking it's a fact are disagreements exist, and the disagreeing bodies have some kind of legitimacy. The Constitutional Court can deliver a stupid judgment, but it does, within the context of its system, have a systemic authority to deliver that judgment. And there's a sort of unresolved tension in how that relates to... And so then it's a fact. And so I'm not saying, you know, should one have pluralism? The fact of these disagreements can certainly present problems for rights protection. Having said that, a non-pluralist perfect hierarchy can also present problems. It depends in a way how good is the person at the top of the pyramid. But I mean, I would try and avoid thinking about it in terms of like, is pluralism an answer? Pluralism is an answer. It exists, and if we recognise it in this language, these disagreements, that does provide us with a potentially constructive way with communicating with each other. And maybe just the last word, I mean, Dan Kellerman's chapter did I think of all the chapters that were submitted, make us kind of like exchange the most emails, and it's like, should we go back to him and ask him to moderate his language or not? You know, and I think if we had 5 chapters like that, it would have been kind of unacceptable, but we felt within the context of a book where we had deliberately tried to get disagreeing people. You know, we tried to encourage people to disagree, and we had said to everyone, you know, this is a Catholic book in the sense of, you know, say what you think. Please, be free. We want to make it stimulating. Well, I thought one chapter like this, even though he probably knows damn well that it's too polemic to get past the editor of a journal, and that's why he's given it to us. But, you know, people are going to enjoy reading it. They're going to enjoy talking about it. It'll be a nice, and in that sense, you sort of prove us right. You know, he makes a point. Probably almost everyone who reads it who thinks he's going to he goes a little too far, but because of that, it's quite a stimulating little collection of words. So we let him have his rant. Okay. That's not going in the film, is it? Sorry.
We'll cut it out.
Please, Mate.
Well, I'll also keep it short. And again, I will agree, first of all, with Garrett that pluralism to a certain extent is a fact. It's a recognition of diversity, of differences. And I think it's what the importance of the very development of the idea of legal pluralism, which of course predates a lot the idea of constitutional pluralism, because the theory of legal pluralism was around and kicking since the 60s, or even earlier with the anthropological approach to law, etc., etc. But in the EU law, it was sort of the development of legal pluralism and constitutional pluralism vindicated and gave legitimacy to the idea that the member states have the right to be different. So the recognition of the fact that this difference and diversity is not something which is just an obstacle to the way of more uniformity, but it is also something, as Weiler would say, which is something, it has something of normative meaningfulness behind the fundamental boundaries, that it stands something, right? That there are certain history, certain tradition, the right to do things differently also collectively as a community. So it has also an important communitarian dimension to it. And I think that's important, but also in a less normative sense, in a shallower sense, as it were. It's also, I think, the recognition that comes from the Scottish authors such as McCormick and Walker, who simply say, well, we have to recognize that these different polities, these different sides of authorities, are these different sides of authorities because they're also different epistemic sides. These are different cradles of knowledge, the way these sides do understand and conceive themselves, the way they conceive themselves of. And I think this aspect was missing in this drive towards uniformity, which has been part and parcel of the modern understanding of constitutionalism, as Tali has explained well. So pluralism in that sense is a fact and is a recognition of the fact that there is diversity. But if this was all to pluralism, then we would only have plurality. Plurality is not yet pluralism. Pluralism, on my understanding, is a normative theory which requires these different pluralist sides, to put it profanely, to build bridges. To build bridges and to engage with one another. So even in the field of human rights, we have this, since the Second World War, we have this idea, this very laïque and to a certain extent very banal idea that human rights are universal. But what does that mean? They are factual, not universal, because they're not equally respected around the world, unfortunately. But we also see that human rights are practiced differently. There are different standards of human rights protection, even in very decent polities. And this goes back to different epistemic understandings and different cultures and traditions and blah, blah, blah. And there is something virtuous, there's something which is in this diversity that is worthy of protection. And on the top of it, in this idea of pluralism as a model of engagement, of dialogue, of justifying yourself, there's also an idea not just of bridging, it's also an idea of checks and balances, right? So, if there was only the European Court of Human Rights who would have the final say, that would be immediately the right answer because of the formal decision that we took that this is the human rights that has the European Court of Human Rights that has the final say. This doesn't necessarily mean that they would have arrived really at the best decision. And as Garrett said, this really depends on the people who sat in that court. So, given the fact that these guys, and this includes men and women, are aware that this decision might be contested, they will try harder. They will try to justify it better. Even though I think still that with the European Court of Human Rights, I think that there is something peculiar and special to the constitutional pluralism inside the European Union. There's a qualitative difference with other regimes. I don't have time to explain this, and other authors have made this argument as well. And that makes it more complicated for the EU. Whereas with the European Court of Human Rights, I think it's a little bit less complicated because I think there is a sort of a shared monistic understanding that the European Court of Human Rights, ECHR, is competent, is authorized to lay down the minimum common standards. And the court should have been sort of aware of that. And sometimes it is, sometimes it's not. And this doctrine of margin of appreciation, I think this is the very recognition of legal plurality and legal pluralism in the European Union. And of course, sometimes you will have these frictions in the borders and the borderline cases, but I think if taken seriously, they can be used for the better, to force CAS really to make their hearings public, right? Or on the other hand, to force the European Court of Human Rights to rethink its decision. You know, what brings to mind the famous Lao Tzu case, right? And banning of crosses in Italy. Of course, on those premises and in those particular contexts, of course, one would say, well, this decision is sound and convincing. But if you take into account that the separation, the establishment clause, is not shared around Europe, that so many other states even fly crosses in their own flags, right? You see that decision was simply too uniformist for the kind of diverse Europe that we have. So I think this kind of stimulus of contestation, separation, checks and balances, I think it's the normative advantage of legal pluralism that we have to cherish. And then I think much would be lost if we succumb to monism.
Okay, thank you very much, dear editors. So, as mentioned before, ladies and gentlemen, dear guests, the floor is yours for any comments, interventions, questions. Just wave me with a hand and we'll give the floor to you. Yes, please.
Thanks for the presentation. I really enjoyed it. It's about legal pluralism. I studied comparative private law, so your PhD. So I'm not a public lawyer. But legal pluralism is so related to comparative law as well because we are comparing different legal systems. My question is that in the private law, I know there is legal borrowing, from different systems, the different concepts. Even though the languages weren't different, but there is a legal borrowing between different systems to develop your own system. It happens in enterprise liability, like in my field, product liability. My question is that now you have a European Union, it's supranational framework, and then you have member states, you have different constitutions, and then you have a human rights chapter, or European Convention, I should say, of human rights. So exist any legal borrowing or innovative borrowing between the different member states, or between European Union and other regions like United States, Australia, or other countries, which shares the constitutional values as European Union did? Does there exist any legal borrowing? The legal borrowing doesn't necessarily mean that it should be just between the courts. It also can be between the scholars, because the scholar contribution are very important for the concepts in the system. That's my question. Thanks so much.
Thank you very much. Maybe any other questions, comments, suggestions? We could maybe take 2, 3, and then the panel can reflect to that. So maybe any other? Please.
Maybe a stupid question. Would the coexistence of the law and of the Sharia law somehow fall into the legal pluralism concept?
Okay. Thank you very much. Yes, please.
I have a question on topic you already talked about desirability of different solutions to legal solutions to same problems. I think it was already 10 years ago that the great late Ulrich Beck wrote rather enthusiastically about cosmopolitan tolerance about Europe, getting rid of straitjacket of nationalism, and as a Europe as a model for the world. Sadly, Ulrich Beck is now dead, and also it seems that the idea of cosmopolitan Europe has changed very much. It is clear, at least to me or to maybe to any Slovenian, that there is a merit in a sort of a nationalism, in a sort of a national identity or even secession. Maybe for those of you who are not Slovenians, there was an interesting case just now. There was a referendum in New Caledonia, a French former colony, and it was interesting to observe the debate or the reporting in the highbrow French, in the highbrow French press. Of course, on the one hand, they are full of colonialistic guilt and etc. So they don't like colonialism. On the other hand, nationalism is supposed to be something also not that pretty. But who would deprive poor Kanaks who are natives of New Caledonia of their independence? Of course, Spain is something different in this line of thinking. So I think that the nationalism now is also a fact in Europe. Particularism, if you want. The other thing is maybe there is also different understanding along the old delimiting lines of the north and south and the east and west. What Europe means, what are the European values, what is the meaning of the Charter, what is the right interpretation of the Charter. This is something that Milan Kundera, in his famous essay, Tragedy of Central Europe, noticed already in 1983, when there was no, where there was just Western European Economic Community. He noticed that the understanding of Europe in his old country, in his old country is completely different than understanding of his French contemporaries in 1983. So there is on one hand nationalism, on the other hand different understanding of maybe the Charter. What is relevant at the moment is, of course, the fear of barbarians. I'm talking about migrant crisis without naming it. Namely, the late Cvetan Tudor, a French Bulgarian linguist, famously said that it's the fear of barbarians which creates a danger of becoming barbarian itself. However, I would say that also denying that the fear of barbarians exists, denying that the different understanding of the same legal text, of the same charter exists, creates a danger of leaving the middle ground from the moderate thinking to the more extreme thinking. So my question would be that, of course, legal pluralism is a fact. It's desirable. I think it's a good thing that it's mainstream, as you mentioned. My question would be how well equipped is at the moment EU law to calculate all these differences, to mitigate them in order for the melting pot not to explode.
Okay, thank you very much. So would maybe the panel like to react to the three questions, comments posed? Maybe we go from this side to this one. So please, maybe.
Okay, thank you very much. Once again, I mean, on legal borrowing, I'll say a few words about each of them. There is, of course, an enormous amount of legal borrowing, an enormous amount of skepticism of whether legal borrowing ever works as well, whether you end up changing it so radically when you place a piece of law in a new context. What strikes me is that in a constitutional context, one of the first things the Court of Justice said when it began to develop its own constitutional legitimacy was it would essentially make up rules and say we are drawing on the constitutional traditions of the member states. And it always did this obliquely. It never cited anything concrete, but it would just produce a rule or a principle and say, well, this draws on the constitutional traditions of the member states. And in a way, this was a kind of borrowing and composition. It would borrow in a very vague, indeterminate sense and produce a kind of a common extract of it. And that's, I think, been quite influential because it's fed back into member states. And what I've also, I mean, I don't know much about this, but I have also read in constitutional scholarship is people saying, as a result of the dialogue between the Court of Justice and national courts, which is in a way is a dialogue which is repeated multiple times. It's very similar it says the same things to all these courts. The national courts have become more aware of each other. And there's a sort of, one way of a networked constitutional court, whereby constitutional courts in Europe are increasingly aware of their peers and increasingly citing them, and so in a way being influenced by their own constitutional ideas. And that's led by the kind of the hub of the Court of Justice. But I don't know much more about that. And on the law and Sharia question, and one of the things I liked about this book is that Edward Elgar were quite clear they wanted legal pluralism and not constitutional pluralism. And legal pluralism is an anthropological idea. Its origins are a legal anthropology. Lawyers, if they're given a new state, will tend to try and find all the norm sources and integrate them into a whole. And try and work out, which ones belong where, but they'll try and integrate it, create a whole. And legal anthropologists would, literally the origins of this were going off to countries that Europeans were discovering for the first time and saying, wow, there's this source of norms and that source of norms and that source of norms, and you have the tribal leader and you have the elders and you have the witch man and so on, and just accepting this as an obvious fact because they could observe that there were different sources of norms. And so a legal anthropologist would say, absolutely, Sharia has a certain normative force. It's a kind of one of the sources of normative power. So is the conventional legal system. So perhaps are other things. And pluralism is recognition of this fact, and then you can begin asking whether it's problematic and how they relate and so on. But yes, they clearly exist, and I think it's quite a constructive thing for lawyers in a way to have in the back of the head and be aware of, even if Sharia is for most of us not part of our life. In a way, your very interesting comments. And we think, did cosmopolitanism also die? Not just Ulrich Beck. Are we seeing a non-cosmopolitan idea of Europe emerging? Well, one of the things that often strikes me is that there's quite a common use of cosmopolitanism in a very shallow way, which you get, it's a sort of self-satisfied inner city perspective, which consists of, cosmopolitan culture consists of having a really wide diversity of restaurants and skin colours. And essentially cosmopolitanism exists when a kind of liberal urban culture successfully colonises people of different origins and cuisines. Say, wow, this is not really, this is almost anti-cosmopolitan, actually. It's an anti-cos. Cosmopolitanism surely must contain the idea of difference. So, meaningful difference, not just how much garlic do you put in the sauce, which is the sort of London cosmopolitanism, of meaningful difference. And so in that sense, I would say Europe is precisely at last becoming meaningfully cosmopolitan. Instead of having it's actually having fundamental differences, but they are still within Europe. I mean, a true anti-cosmopolitan nationalist would be sort of like an atheist thinking about God. They don't. There's nothing to think about, in their view. So a true cosmopolitan nationalist would have no interest in Europe other than to reject it. An anti-cosmopolitan nationalist. Whereas I think what you see more now is a sort of nationalist view of Europe. And that seems to me a true cosmopolitan, because they do accept that they are part of a greater whole. They do accept the desire and the need to get along, to, in a sense, be integrated. But the question is, how do you do that? And it seems to be important to accept that without having to necessarily agree with every racist statement that's made, but to accept this as a principle, that cosmopolitanism is meaningful if it includes those that you really quite strongly disagree with. And particularly the fundamental question of the levels of community and the way that you organise. Everyone accepts it. Was it Linda Bosniak who said there's no inside without an outside? You need communities. Everyone likes communities. Every community involves exclusion. Tough fact of life, and the question of the best, the optimal organisation of community and how that works and which level it works is always going to be an ongoing political fact. And we're seeing certain ideas about community coming to the fore, and there'll be a churn, and they will go away, and others will come up. But the containment of really strongly disagreeing ideas about how community should be organised within a peaceful, shared frame, it seems to me, at last, we are getting cosmopolitanism. Like, in a way, as Pietro said, it's sort of like pluralism becoming real, not just being theoretical as in the book, but actually starting to become real. But, of course, the question is whether it will all fall apart. And, yes, I mean, who knows? I'm actually sort of fairly optimistic, because in many ways, throughout the history of the European Union, there have been people saying, but, this is unprincipled, wrong, how can the Court of Justice get away with this, etc., etc. What I'm encouraged by is the fact that most of the nationalist voices do not reject Europe. They call for a different kind of Europe, and that's quite an important shared starting point. I'm not saying it's going to be enough, but it's a certain limited reason for optimism.
Okay.
So,
I will also just comment briefly on the 3 points. First, to start with the private law and the question of borrowing. Of course, there's a lot of you could even use the language of computer science. There's a lot of uploading and downloading between the member states, and also horizontally and vertically. The legal institutes and institutions are traveling, but the European Union. The comparative law, it's to approach the European Union in the question of traveling and exchange and borrowing. Comparative law is to a certain extent too slow for the European Union. It's like in the pre-digital times. In the European Union, everything's been digitalized, and you have the common constitutional traditions that have somehow borrowed and then somehow traveled back to the national level. With regard to Sharia. Well, as Garrett already said, of course, from the anthropological perspective and from the conventional legal pluralist perspective, Sharia is the community that it governs, in the communities it governs, it's considered as a legal order, or at least a legal ordering. It has strong normative power for them. Of course, this then raises the question of engagement when Sharia hits Western law, and this then entails a question of the limits of legal pluralism. What are the limits of legal pluralism? How far can we go and recognize the practices dictated by very different legal orders and orderings? And my answer here would be my argument has been that there is a monistic foundation to legal pluralism, and that's the recognition and respect for equal human dignity. So the measures that would be imposed or required by certain legal orderings that would interfere with or even encroach upon or take away from something which is the essence of human dignity, I think that is something that it is there where the limits of legal pluralism come across, and there's sort of a break should be put. With regard to the cosmopolitan Europe, I've always thought that I've always been attracted to the idea of pluralism, pluralism as such. In the years of studies and reflecting on the legal pluralist theories and the constitutional pluralism, I realized actually that's something that has something grown in me as my own ethical moral ethos. And I understand pluralism as an ethical standpoint that requires, that entails precisely what you were pointing at. So that is sort of connecting the particular with the universal, providing the language of accepting these differences inside the European Union. It is not a pluralist standpoint. It is not an expression of pluralism if we simply close our eyes in front of the fact that there are different understandings, even of the most fundamental provisions of European law, even of the Charter. And pluralism requires the recognition of these differences, of this plurality, and then engagement and and finding the ways of justifying this, and then finding that not I wouldn't argue for harmony, but of at least in a certain way of coexistence within the common whole that we share. And it is true, as we know it, whenever any kind of system comes under stress, it always has a monistic tendency. It always has a monistic tendency because differences and diversity is perceived as a threat, right? So even nowadays in the European Union, the way I see it, the way it can develop, we have threats coming from two different types of monism. One is old monism. So we simply disband the European Union and we revert it back to the member states. So it's we take our competencies back. It's been called repatriation and create global Britain, if you like. So we take the control back and we'll be nicely put behind our own confines of a nation, a glorious nation state where we are more or less homogeneous and we will have control over all this. And those irritants from outside, from external irritants, we can get rid of. Of course, the approach which is opposite to this is the approach of the new monism. And the new monism simply says, well, let's get rid of all of these national irritants and finally create the state of Europe. And finally make sure that there is the European Court of Justice, which has the ultimate and absolute final say, and that all the provisions are understood uniformly, and that those who are not on board, as Kellerman would say, they're free to leave. They're free to say that and they're free to leave. And this is what you many times hear from the center of this new monism, of course, from Brussels, from the Brussels elite, right? Because they simply do not, their epistemic frame through which they gaze at these developments is simply this kind of a new monistic frame of Brussels. And pluralism disputes both of these approaches. It recognizes that they have the legitimacy on their own epistemic premises, but they have to try and look beyond those epistemic premises and engage into a certain common whole. And what fills me with optimism in the European perspective is precisely what Garrett's been putting forward all the time. Even the nationalist voices are saying, well, we want to build it, we want to stay inside this European frame, but we have a different vision of it. And, there is a different vision coming from Brussels and other more centristic member states. So be it, it's correct. And now we have to the process of engagement, dialogical engagement, deliberation, find a way of, satisfying these preferences in a sort of a via media that would, to a certain extent, satisfy all, but always just provisionally. Then we'll have to move on because the contestation will continue. For legal pluralism, the system is constantly alive and kicking. It never cools down completely. The forces are constantly alive because they stem from this legitimate diversity that's constituted of.
Thank you very much, Matej. So, our two commentators, maybe first Jerne and Pietro.
Yeah, much has been said already on the question, but maybe just to add some points. Maybe to first one, what Žiga asked. Of course, I mean, Sharia, it's a pure example of both empirical legal positivism, but also normative. Because there exists, for example, Arab Charter of Human Rights. There you will find provisions such as torture is prohibited unless it contradicts Sharia. Of course, I mean, when you read that, and then the question is what Matej asked, I mean, how desirable is then legal pluralism in this context, where the thing is how to solve this conflict. Of course, from our perspective, we know what will be the answer to that. No? Or, for example, how to react to a customary law of Zulu tribe in Botswana and South Africa. There, for example, women can only inherit after their husband if they are cleansed, if they have sexual intercourse with one of the brothers of that late husband. Of course, that contradicts, several provisions of our Western human rights norms and so on. And then, of course, how can we have a dialogue with such a customary rules? It's a bit more difficult. Then to the third point, what Micha raised. Of course, you're right. There is a rise of particularism and nationalisms, and people who live in New Caledonia, of course, they have quite clear right to self-determination because they are former colony, their colony. So there is no objections in public international law to their wish to create correct state. But I'm not sure. You mentioned just obiter dictum, if I heard you right. I'm not sure if Spain is it's a different example. You know, Spain and New Caledonia, maybe from a public international point of view, but from constitutional law, public or legal pluralism, they're quite similar. Facts. There are people who try to express their wish, both in Basque Country and in Catalonia, and there is, of course, a quite strong opposition to that. You know? And here we can connect it to legal pluralism, where Spanish Constitutional Court and all branches of Spanish government employ legal monism to interpretation of who is the people in the Spanish economy. Of course, it's only Spaniards are the people, not the Catalans, Galicians, or the Basques. And this is quite dangerous. When in the national domestic polity there is a higher authority which goes against the facts on the ground, and of course when one follows what is going on in the Spanish Parliament, where, for example, today there were one side was calling the other golpistas, as the ones who tried to make a revolt. The other side was reacting, calling them fascists, and so on. And it's very tense environment. And of course, I agree with that. That the only solution is then there is dialogue, arguments, debate. But then, what happens if one side does not recognize the legal authority of the other? How can you force the other side to start dialogue? And how can legal pluralism address that?
Okay, so please, Pierre.
Easy job for me because I don't have so much to add. Regarding the third question, I couldn't agree more with Gareth's reaction, and in particular with the cautionary note in regard to the shabby chic cosmopolitanism, and so I will not add any other reaction. With regard to the question of Sharia law, I think that if we analyze it just in neutral terms and we just look at the frame, there is nothing exceptional in it. I'm coming from a country where ecclesiastical law, which is something perfectly similar just with regard to another denomination, is part of the constitution. So we apply ecclesiastical law with a constitutional protection with exactly the same legal force of European law. So it is exactly the same position in the Kelsenian pyramid of sources of law. And of course, also with regards to ecclesiastical law, we have developed in constitutional jurisprudence theory of counter limits that is somehow similar to the one that the Constitutional Court in Italy and elsewhere developed with regard to the European Union. So I think the point is that, is it a phenomenon connected with legal pluralism? Yes, certainly. Do we have to investigate and elaborate limits on constitutional pluralism, on legal pluralism? Yes, we have to. And I think in the European Union, there are all the tools to develop these kind of limits. And if we think about, the Cadi judgment, emerging core of European constitutional identity already exists, and I think we have to insist on that. On the last point on legal borrowing, I think yes, of course there is. So in the constitutional legal space, there is an exceptional quantity of legal borrowing, both in the vertical sense and in the horizontal sense. But we have probably to act with caution, because there is also a huge abuse of legal borrowing, and I think that the jurisprudence regarding national and constitutional identity is one of the clearest example of abuse of legal borrowing. Thank you.
Okay, thank you very much to both commentators. So we have exactly 10 more minutes till the end. So I would, if there's maybe one very short, but really swift question, comment, like minute maximum. Please, maybe first, yeah.
In Slovenia, we lately had some disputes between freedom of speech and hate speech. I believe it can be both used in wrong ways. So in comparison to that, I'm asking you how to determine when legal pluralism is used to balance the power, and vice versa when the stupid judgment, as Matej mentioned, are used as pluralism. Who should be the one who determine the difference in these cases?
Thank you very much. We have one more intervention here.
Thank you. First, congratulations to both co-editors on the book. Judging by the leaflet and discussions, I think it's already a great contribution to the field. My question pertains to the mechanism of enhanced cooperation within the EU, because that might be an example of legal pluralism as well. We know that it was introduced some time ago already, and that now under the Treaty of Lisbon, actually, although there was a lot of criticism, somehow lately there were a lot of examples of it, more, let's say, in technical areas like divorce law or patent law and so on. But on the other hand, we also had this white paper of the European Commission last year, in which the Commission somehow suggested scenarios on the way forward of the EU, precisely in that direction, how to be unified within diversity, or how to be diverse within unity. So, what do you think about that?
Okay, thank you very much. I have with this I have to close the questions and the interventions, and it gives me the pleasure to ask the two co-editors of the book maybe to provide your final comments, maybe in just a couple of minutes each of you, and maybe try to also answer these two interventions, these two questions on the side. So each of you have a couple of minutes to finish the debate. So what would be your final streamlines, ideas, comments in regard of the debate? So maybe please we start with you, Matej, and then finish with our guest from abroad. So please, the floor is yours.
Thank you, Gorazd. Thank you also for the last two questions. Very interesting indeed. In terms of who is to say whether there is a particular judgment is a stupid one, well, legal pluralist answer would be we have to provide and we have to allow for a plurality of voices, and then they sort of compete with their most persuasive justification, and in the end we come out with a particular result. And here in this particular case that we both are referring to, the stupid, well, the judgment itself wasn't stupid. The stupid was the reaction, and here you could see that a whole plethora of very different individuals with very different worldviews, with very different understandings of law and approaches to law, have come to a joint conclusion that this was a stupid reaction. And I think in that sense, pluralism has driven these individuals to a common and widely shared conclusion. So the idea of legal pluralism is that there is no one single institution who has the final say. There is a competition of voices. In terms of differentiated integration, precisely, that was one of those case studies that somebody that invited me to work on my PhD years ago, precisely because it's always been regarded as sort of an anathema in EU law. It has gone against the grain. It has gone against the grain of uniformity of EU law. And Deirdre Curtin, your Amsterdam colleague, not necessarily the same university, she wrote a famous and fabulous piece immediately after the Maastricht judgment, where she sort of bemoaned and she was crying about the constitutional monstrosity created by the different pillars of the Maastricht Treaty that weren't unified as the before existing European economic communities. That, I think, that article really demonstrated how the predominant or the dominant or the mainstream legal academia perceived the way the EU law should have been. Later on, as you rightly put it, differentiated integration has become gradually, first mostly on the paper, but then also more and more implemented in practice. On my reading, as a legal pluralist sign of recognition of diversity inside the European Union, something which grants certain legitimate diversity to certain claimed diversities, and that it still exists. The certain member states have the right to do it differently, to be part of a more accelerated procedure of integration, yet still being part of the common home. So I read this as an example of legal pluralism, or even legal pluralism inside the European Union, and also an example of it, and also a sign of legitimation, of justification of this theory as applied to the European Union.
Okay.
And I think we'll see more of it, and rightly so, because the differences are deep, and they have to be acknowledged.
Thank you. You know, there's a thing that children sort of say, I don't know if children say it in Slovenian, but in English at least, you know, they say something like, that's my opinion, you can't argue with me because that's my opinion. And you know, I think in a way, legal pluralism tries to sort of steer a middle way between, on the one hand, the kind of facile point of view that, you know, all opinions are equal because everyone's allowed to have an opinion. And on the other point, simply saying, well, you know, someone's right and the other one should be crushed. Mm-hmm. You know, and what it does is it recognises that there can be a standpoint which you can fundamentally disagree with for content-related reasons. You can say, it's bad reasoning, your values I reject, etc. But nevertheless, recognise there's a certain systemic or institutional legitimacy to the decision. So you can take a balancing in free speech and hate speech, and you can say, you know, what an appalling judgment for this reason and that reason, and you critique it. It doesn't have to entail a rejection of the sort of systemic legitimacy of the decision. And the alternative is what you sometimes see in the United States debate these days, which is a kind of polarization whereby, you know, like this Trump thing that happened a couple of days ago, you know, if a court says something you fundamentally disagree with, you essentially deny the legitimacy of the court. So yeah, stupid court. And that happens sometimes in sort of activist circles where people are so concerned with the result, the end result, which must be the banning of this, that they tend to conflate that with the systemic role of the decision maker. And I think, you know, argue passionately against, if you like, bad decisions, that doesn't necessarily entail a kind of like a institutional sort of tyranny or whatever. It's to end with this question, which just sort of opens up a whole new topic, which could be the subject of a book or a conference on itself. But it is very interesting you raise, because there's nothing that I think frightens traditional EU lawyers of the kind of the old caste more than enhanced cooperation. Because there is this very, in a way, French commitment, I say that as an Englishman, very sort of French commitment to a kind of uniform, rational structure. And in seeming to deviate from this, there are many, and this is why it doesn't really happen much, that it will, then the whole thing will fall apart. In a way, as your colleague suggested, is this sustainable? Can you sustain this? Well, I mean, you know, time will tell whether that's... It's interesting to think of it in terms of pluralism, and I haven't actually heard that perspective more, but when you put it that way, I suppose in a way it is a recognition of the legitimacy of different points of view and an attempt to bring them within a common frame by making the broader frame flexible. And I wouldn't, as I think we'll probably hear a lot more of thinking about it in these terms in the future.
Okay, thank you very much. And in my power of my role, we are exactly on time, so it's exactly more or less 6 o'clock, so the way we promised that we will finish by 6 o'clock. So my duty would only be to thank the two commentators for sharing their thoughts, their ideas about the book, and of course our two editors who prepared the book, and congratulate them once more for the book, for their achievement which they prepared, and also shared them, these ideas today with us, and of course to all of you who were here with us and joined this presentation of this book. So thank you very much for coming, and hope to see you on the next event which we will prepare at this premises. So thank you very much.